You know, we've all heard those horror stories about battles with a homeowners association, right? Well, today, we've got a story that's a little different. It's about a seemingly simple dispute over a tree and a few $100s in fines, but it spirals into a full-blown legal hearing that ends up turning on the definition of a single word. It's just a fascinating look at how the rules we all live by are only as solid as the words they're written with.
So, right off the bat, you get a sense of where this is going. This quote is from the homeowner himself, Jerry Webster. You can just feel the frustration coming through in his official petition. He was convinced he was being harassed by his HOA with these vague notices, and he decided, you know what, enough is enough. He was ready to fight back.
Okay, so let's set the scene. We're in Scottsdale, Arizona. Our guy, Jerry Webster, is part of the Mountain Rose Homeowners Association. And for years, he'd been locked in this simmering feud with them. And it was all about a single tree on his property.
So between 2016 and 2017, Mr. Webster gets this whole string of violation notices about his tree and some debris. Now, according to him, the notices were super unclear, and whenever he asked for clarification, he just got silence. And then the fines started rolling in, $175 in total. For him, that was the final straw. He decided to take this whole thing to an administrative hearing, and he came armed with the HOA's own rulebook. He was sure he'd found his smoking gun right there, inside the HOA's official governing document, what they call the CC&Rs. You can think of it as basically the community's constitution. And he zeroed in on this one section, Article 10.8, called Notice of Violation, totally convinced the HOA had dropped the ball and not followed their own procedure.
And listen to this. This rule was incredibly specific. A formal notice of violation, according to their own book, had to include 5 key things: the owner's name, the legal description of the property, what the violation was, a statement that the notice was being officially recorded, and, this was the big one for Mr. Webster, the exact steps needed to fix the problem.
And this really gets to the heart of his whole case. On one side, you've got the official rule demanding all this super specific, almost legalistic information. And on the other side, the simple letters he actually got, which he argued were missing pretty much all of it. No legal description, no mention of being recorded, and, crucially, no clear instructions on what he was supposed to do.
So, from where Mr. Webster was sitting, this looked like an absolute slam dunk, right? He had the official rulebook in one hand, the notices they sent him in the other, and the two just did not line up. I mean, how could he possibly lose when the HOA wasn't even playing by its own rules?
And it's so important to remember what was actually on the line here. This whole fight, all the paperwork, the legal battle, it wasn't for a fortune. It was over $175. But for Mr. Webster, it was never really about the money. It was about the principle of the thing. He felt the process was totally unfair and those fines were completely invalid. So here's the million-dollar question. If the rules are so crystal clear and the notices he got didn't follow them, why on earth was his petition completely thrown out by the judge? This, my friends, is where the whole story gets turned on its head. The entire case, which seemed so airtight, so solidly built on that rule in Article 10.8, just completely fell apart. And it all came down to how you interpret one single powerful word buried in that very same article.
And that word was recorded. See, Mr. Webster saw that word and probably thought what most of us would think, that it just meant any official notice, something written down. But in the world of legal documents and contracts, words can have these very specific hidden meanings that are totally different from how we use them every day.
And here it is. This is the kicker. Tucked away in a totally different part of the rulebook, Article 1.33, there was a definitions section. And it gave a very precise, very legal meaning for the word recording. It didn't just mean writing something down. It meant formally filing a document as a public record with the Maricopa County Recorder's Office. And that right there is a huge, huge distinction. So once that hidden definition came to light, Mr. Webster's entire argument was just poof, gone, and the judge's logic suddenly became crystal clear. The HOA's lawyer basically just had to point out that the letters they sent to Mr. Webster were just informal warnings. They were never actually taken down to the county office and officially recorded as public documents. In fact, the court files say there was zero evidence that the notices were ever recorded. And here you can see the judge's own words delivering the final blow. The judge says that the strict 5-step rule in Article 10.8 only applies to notices that are officially recorded. So since the letters Mr. Webster got were never filed with the county, that entire rule, the very foundation of his case, it just didn't apply.
And just like that, the judge's order was simple and final. Petition dismissed. Mr. Webster had failed to prove his case. The one-word fight was over.
So why does this story even matter? I mean, it's more than just some neighborhood squabble. It's a really powerful lesson about contracts, about rules, and about the very language they're built on. It really shows us that when you're talking legal documents, the devil is absolutely in the definitions. So what's the big takeaway for all of us? Well, first, and this is the most important one, a specific definition in a document can completely override common sense. It doesn't matter what you think a word means, it only matters what the contract says it means, which makes that definition section of any contract absolutely critical. We also learned that not all official-looking notices carry the same legal weight. And finally, it's just a harsh reminder that the burden of proof is on you. Mr. Webster couldn't prove the notices were recorded, and that was that. You know, this whole case leaves us with a really tough question to chew on. Mr. Webster clearly felt he was being treated unfairly, that the notices were vague, that he was being harassed. But the law, as it was written in that rule book, was on the HOA's side. All because of one little definition. It really makes you wonder, in a world that's governed by rules, what happens when our idea of what's fair just doesn't line up with what's technically legal?